All right, we're going to come to order the Board of Equalization meeting. Today is Thursday, February 20th. We're meeting in the Board of Supervisors hearing room in Bisbee, Arizona. The item on this agenda is open for discussion and possible action. Members of the Coachella County Board of Equalization will attend either in person or by telephone or video conferencing. Members are also able to attend this meeting by Microsoft Teams or by phone. The board may permit public comment during the discussion of any item on this agenda. To speak on the agenda item, complete return the speaker request form. The clerk of the board will receive those prior to the meeting, which is right now. So we'll begin with the roll call. District 1.
Good morning again. Mr. Chair, Crosby is here.
District 2.
Gomez is here.
In District 3, Antonori is here. All members are present. Mr. Crosby is attending by Microsoft Teams. And we will begin with the first agenda item. Can I get a motion?
A motion that we ratify or amend the decision of the State Board of Equalization, SBOE, hearing officer regarding the notice of claim appeal hearing held on January 8, 2025 for tax years 2022, 2023, and 2024, filed by petitioner Stronghold Farms, LLC, Aaron Matowski.
All right.
Second.
All right, thanks, sir. Let's have a discussion. Mr. Leindecker, the floor is yours.
Good afternoon. Mr. Chairman, board members, you have before you this action, which is a notice of claim of an error, and this was filed under the tax roll correction statute, which is entirely separate from the valuation appeal statute. The property, to give you just a brief oversight, the subject property is 158 acres of vacant land. It was purchased by the claimant in December of 2021. The purchase price was $850,000. The property was identified on a recorded affidavit of property value as vacant land, and the property owner, after having purchased this, received a valuation notice for 2023, a valuation notice for 2024, a valuation notice for 2025. For 3 years in a row, their notices were sent notifying the property owner of a full cash value of $367,779, a limited value of $367,779. There was no administrative or judicial appeal filed on this property for either one of those 3 years. Then in October of 2024, the property owner filed a notice of claim claiming an error. Now, the notice of claim statute is very specific. That notice of claim statute is specifically ARS 42-16251, which defines an error as something that's verifiable, that doesn't involve discretion or opinion or judgment. It's not a valuation appeal. It's an error specifically where it can be proven and documented to be an error. That allows us to fix a tax roll assessment. We can go back on such an error. For example, if your home is actually 2,000 square foot in size and we have it assessed as 2,500 square foot in size, that's a verifiable error. That's something that if a property owner files a claim under this statute, we can verify that it's an error, and this statute gives us the ability to go back and fix those types of error. It's very specific. In fact, part of that statute under 42-16256 actually specifically restricts the tax roll correction process to only those verifiable errors. And if you have a valuation challenge or a classification challenge, that has to be handled under the annual valuation appeal process. That's entirely separate from a tax roll correction process.
In this case, previous 3 years.
That's correct. That's correct. And then after the fact, the claim had been filed then for years 2022, 2023, and 2024, claiming agricultural classification. Now, the agricultural classification in this particular situation, the property was purchased in December of 21. Under the statute of ARS 42-12153, the new owner has 60 days to file a new agricultural land use application with the assessor if they want agricultural classification continued on property.
So it was classified agricultural.
Prior to the sale, it was. That's correct. So that never occurred. And that statute also specifically states that the assessor shall not value property as agricultural property unless that application is filed with the assessor. So that's a very strict, solid direction to the assessor. Yes. So in this case, the claim for an error in this situation was that the property should have been valued as agricultural property, and it wasn't. Therefore, there's an error. And based upon the statute, my office had to deny the claim. And in fact, we denied the claim at the A level, at the assessor level. The appeal was then appealed on to the Board of Equalization. The Board of Equalization hearing officer then held this hearing on the 8th of January, in which my recommendation from my office was that the claim had to be denied because there was no basis, there was no error. After much discussion with the property owner, the hearing officer actually sought direction from our county attorney's office. Our chief deputy county attorney was online, provided her with direction that in fact there was no error, that in fact the claim should be denied, and the recommendation of my office was correct. And after receiving that direction, then she opened up to a valuation appeal and actually changed the classification and actually handled it like a valuation appeal, which obviously, based upon my office and the direction from the county attorney's office, is an incorrect action to take. So based upon the direction and the statutes that my office has to work on, I must recommend to this board that you amend the decision of the state equalization hearing officer and deny this claim. That's correct.
It was not agriculture, and then
Yes.
they didn't do anything about it.
That's right. They waited basically 3 years before they did anything about it, which they can initiate an application at that point in time, but you can't go for back years
Right.
on it.
And you physically have someone from your office go out to verify agricultural use when that transfer occurs, correct?
Not when it occurs. We wait until that application is filed.
No, I'm saying if he bought the property and within that time period, the 60 days, he reapplied for the ag use.
Yes.
You physically verify that he's continuing whatever the agricultural use was.
That's
of that
correct.
property.
I have ag appraisers that actually that's
Right. So
that's,
because that never happened, because he never filed the paperwork to transfer the ag use, no one ever went out there for 3 years to verify that it was under agriculture use.
the statute says that I can't value it as ag
Okay.
until I
okay.
get that.
Okay.
So whether it's actually used in agricultural purposes is irrelevant. It's the valuation is predicated upon them filing that application with my office before I can value it as ag.
So let me ask you a question. When you're buying property and it has that classification, would the attorney or would somebody tell you, hey, by the way, you've got to go file a document within 60 days, or are they just supposed to know about it?
Well, generally that is pretty much understood with people in the industry.
Okay.
If you buy ag property and you're aware of ag property, you know that.
And did they use it for ag purposes?
The qualifying ag, after the fact, an agricultural application was filed with my office, and we had to deny that because it was allegedly leased to a non-qualifying operator. So the whole reason to filing that ag application is we have to qualify and make sure it's a legitimate lease and a legitimate operation. And every year is a new assessment year. So if they miss 1 year, they can come in the next year and file. But the statutes are real clear on agricultural property because agricultural values are considerably below actual market values. So in cases where we have to, there's so much involved, we are very compliant with the statute to verify and make sure that it's meeting the statutory requirements.
Okay, thank you.
Any questions, Mr. Crosby?
Yeah, let me make sure my mic's on. My mic is on. Yeah, I was going to say, in my opinion, Mr. Leindecker has heard many accusations of, quote, just wanting the taxes. However, my observation has been the opposite, that Mr. Leindecker has been forthright in all instances. I've read some of the appeal statutes about agriculture use, and I know there are time periods in which appeals must be made. Overall, in my previous experience, the only time I remember a debatable gray area was whether the square footage of the interior floor should be measured or the outside area, for instance, of the foundation should be measured when determining the size of a building. So I would recommend going with Mr. Leindecker's recommendation.
All right, is Mr. Latowski here? Didn't we have
Chairman Antonori, he is online and
Okay.
it looks like he's unmuted himself.
All right. So any questions for Mr. Leindecker before I go to Mr. Latowski? No? Thank you, sir.
Thank you.
Appreciate it. All right, Mr. Latowski, would you like to add your argument for why we should amend or not amend the Board of Equalization hearing officer's finding?
Yes, sir. And good morning.
Good morning.
I have a statement I typed up. It takes about exactly 5 minutes, I think. But one thing I
I'll
wanted
give it to you.
Okay, thank you.
You can read it. Go ahead.
And one thing I wanted to point out that came up during the previous statements, I did in fact purchase this property December of 21, and I purchased it from the rancher that had been running cattle on it since 2018, and with the understanding that I would lease back to him so that he and his partner could continue running cattle continuously on that parcel. And I do have a nearby parcel of 80 acres, which I went through this process several years ago, and I did buy vacant land. I did lease it out actually to the same tenant, Mr. Cavey being one of my tenants, and I leased it for a few years while I was preparing my pistachio operation, and I filed all the paperwork, and that operation was taxed appropriately without any incidents. So I am familiar with the program. In this particular case, I bought this property at the very end of December 2022, and I immediately signed a lease with Mr. Payne, who is in partnership with Mr. Cavey, two ranchers that have run cattle on this property together under a partnership since 2018 through the present. And I also filed the agricultural land use application in the same manner as I had before, and I mailed it in. I do have evidence of a copy of that application as well as a copy of the original lease from 2021. And I would like to point out that you'll learn more about this case as I speak, but I was requested again after I submitted it early 2022 to submit another copy in 2023 because the first copy appeared to have been lost. And then in 2023, and then in 2024, I was told that they didn't find Mr. Payne a qualified tenant. So then I was requested to send yet a third copy. I have copies of all three applications and all three leases, The first one, I've made the mistake of not sending certified mail. The second two, I do have certified receipts.
When were those sent? The second two?
One in 2023 and then one in 2024.
Okay.
And the reason the second one was sent is I had spoke with the office. I was told they apparently had lost the initial application. The deputy assessor did testify at the last hearing. He was aware of applications that had been lost. So they said, please send a copy of the original. We need to see that, but we need a fresh copy because we require a wet signature, which of course I had previously mailed. So the second one from 2023 was an exact copy of the 2022 application. The 2024 application, I just had to change the tenant because they were continuing to tell me that Mr. Payne's name couldn't be on the lease, and that is the error in taxation, and that's the basis of my complaint. So let me pick up here where I left off here. So my taxes increased by a factor of 188 times from $36 total for this parcel to $7,500 per year, while the exact same cattle grazed on the land from 2018 through the present. As a agricultural layperson, I'm not able to tell from the full cash value, etc., on that card exactly what the taxes are. It didn't really dawn on me initially that they had increased the taxes from $36 to over $7,500.
Did you pay the property taxes for those tax years?
So when I figured it out, normally I pay kind of like in the summer the first half, and then in the fall the second half. And I logged into the website and saw the bill was $7,500. And when I picked myself up off the floor, I called the assessor's office, and I talked to someone who was very nice and said, "Don't worry, we're far behind. We've had a lot of staff changes. Just be patient. Your application, I don't see it, but we'll find it. We'll correct the error. Don't worry."
And when was that? When did you call in?
That would have been in like the summer-ish of 2022. And here's the thing. I maintained contact with them. She said it would take a few months, so about every 3 to 6 months I would call in and request, any updates. And everyone was very pleasant, but I was told that there was a lot of turnover and that they were far, far behind, and I just needed to be patient, that they would reach out to me. And this didn't really seem out of the ordinary to me because I was dealing with a government agency. After, it should be noted that I called, even calling only about every 3 to 6 months, eventually someone there that I spoke with explained I was calling too frequently and I needed to back off and be patient. At that time, I did ask if I should file any paperwork or appeal, and I was told not to file anything such as an appeal, as an inspection was pending. They said they were extremely booked out. There was only one person that could do the inspections, and I was going to have to wait a long time. Eventually, after a lot of patience, I did receive a denial of grazing status by the assessor. The assessor stated that the denial was based on the claim the assessor's office did not consider one tenant, Mr. Douglas Payne, a quote owner-operator. This conclusion is in error when reading Arizona Revised Statutes 42-12151 through 12152, particularly in combination with the Arizona Department of Revenue Agricultural Manual, which has supporting statutes 42-11054, Section A1 and 2, and statutes 42-13051B and 2. Therefore, I realized an error had been made. Per Arizona Revised Statute 42-16251 through 16258, when taxes are assessed in error, Form 82179B should be filed to the county assessor. I followed these steps. The denial was again reported. I had a subsequent hearing with Mr. Joe Alvarez. and again was told that the denials were due to the assessor's previous position regarding one of the two tenants, Mr. Douglas Payne, who had signed the lease. Of note, there was no mention of anything to do with timing of the application. All denials were relative to not recognizing Mr. Payne, who had signed the lease only because he had previously owned the land and had grazing status with the same herd of cattle that are actually still there at this very moment as we speak. After this denial, the next step is filing Form 82179C-1 to the State Board of Equalization. The State Board of Equalization held a hearing on January 8th, 2025. The board reviewed the evidence and awarded my appeal based on that evidence. Perhaps after I'm done, the State Board of Equalization would be allowed to comment at this hearing if anyone is present. Subsequently, after I was awarded my appeal, the County Board of Supervisors reportedly reversed the State Board of Equalization decision at a hearing that I was not notified of or invited to. Shortly thereafter, I received an email from the county clerk, the Cochise County clerk, that there would now be another hearing since I was not previously invited. However, she stated no new evidence would be allowed or considered. Of note, this is in violation of Arizona Revised Statute 42-16255, Section A, which states in part, in any hearing before the county or state board, either party may present any evidence regarding property tax errors regardless of whether the evidence was presented when the notice of proposed correction or claim was filed. The same ranchers that have been leasing and grazing my parcel from 2018 through the present have grazing status on several adjacent parcels, one of which 119-13004Y consists of 220 acres taxed at less than 25 cents per acre. Another adjacent parcel to mine, parcel 1198-01-00300, consists of 379 acres, which also has a herd of cattle grazing. This is also taxed at 25 cents an acre. Please recall, due to the error, that the assessor increased my tax rate over 188-fold from less than 25 cents an acre to over $45 per acre. The key error made by the assessor's office in not considering Mr. Payne a qualified tenant is that within Arizona Revised Statutes 42-12151 and 42-12152, in combination with the Arizona Department of Revenue Agricultural Manual, there is no consideration given to contractual intricacies, in this case between Mr. Payne and Mr. Cavey. Hence, the assessor's error in denying their partnership and denying Mr. Payne as a qualified tenant is in error. The statutes are very clearly relative to the actual use. In this case, Mr. Cavey is indisputably a tenant. It is testified in writing and has been since 2018 through the present. And he is indisputably a bona fide qualified tenant, as he leases with the exact same cattle herd that are on my parcel part of the time, adjacent parcels that do have grazing status. Therefore, the decision by the State Board of Equalization to award my appeal should be upheld. That's all I have.
All right, so I'm trying to follow the facts here. So I'm reading the statute right now. I got 42-121-51. So you're claiming you submitted in early 2022 an application to transfer the ag use, but you don't have evidence of that. You didn't send it certified mail, so you don't have any evidence of that. The next one you sent that you did provide evidence for was in 2023. When in 23 was that? What month?
I've got such a pile here. I can find it. Part of the problem with that one, recall please, that as I was calling the assessor's office about every 3 to 6 months, they kept suggesting that I just wait and be patient and not do anything different. So I did
I'm just trying to,
wait
I'm trying
and
to get
wait,
the,
but if I had to guess, I believe it was around November of 23. I have it here, but
so late in November of 23.
yes,
Hang on one second, Mr. Leindecker. Do you have any evidence of receipt of that?
The initial application, there was no evidence whatsoever.
Right, right.
And that's
And that's the basis of the. Yeah, I got it. I'm trying to establish a timeline here. Did you guys get one from him in November 23?
we received one November 20th of 23.
Okay, so that is the application he's referring to that was denied because of the tenant not qualifying as a legitimate.
I believe that's correct.
Did he not have what the statute here says 40 animal units or whatever?
He did not.
He did not have 40 animal units.
He owned 0 cattle according to our records.
Okay, and those records are tracked through the ag department.
Well, and through brands. Yes.
Okay.
may I just point out though that gentleman has several adjacent parcels to mine and has been granted agricultural grazing status, and he has testified that he is in a partnership with Mr. Kenneth Cavey, who also has cattle on my parcel.
The problem is the statute requires the owner of the cattle to verify that they are at least grazing at least 40 animal units, not necessarily the partnership. So,
and all of these issues that we're talking about do not affect the years in question.
Right. I'm just trying to, for myself understanding here, I just want to make sure what I'm.
So here's how this broke up. Mr. Payne owned this acreage. He sold part of his acreage to the petitioner.
Okay.
But Mr. Payne had leased his property to a third party and qualified under the third party.
Okay, so
That's the way. That's the
Payne's
reason.
cattle was actually owned by the third party.
Payne has no cattle.
I got you.
Payne was qualifying as ag because he had a legitimate lease with the third party. So,
Okay.
So when he sold this property, Mr. Latowski, Dr. Latowski leased it back to Mr. Payne.
Okay.
But Mr. Payne was not the qualified operator.
I got you.
So it didn't fit.
Yeah. So.
Yeah.
All right. So then.
Mr. Payne does dispute that. He says he has receipts. He has 40 cattle. He's a bona fide operator.
Well, that's a hearing for another hearing, unfortunately. So, so now the 24 application, when was that submitted? Mr. Latowski, do you remember?
I can pull it. I mean, I have to just dig for a minute, but maybe the assessor has it.
I'm not sure if I have it because it's irrelevant to this matter.
I got it. I was just curious. So what I'm getting at here is, this is just me speaking here. So clearly there was an issue with not filing in a timely manner the initial 60-day petition to transfer the ag status. Part of transferring that ag status requires, under the statute, proof of 40 animal units use on that directly, which seems to have not been able to have been established. So I would argue that based on the evidence that I've heard so far here, is that the assessor's recommendation up until that 2024 for those tax years 2022, 23, and 24, because the petition wasn't filed until 24, would still fall under the standard assessed value for vacant land not in agricultural use.
That's correct.
Yeah.
My only concern with that is that the statute states specifically that it's the actual use of the land, which Mr. Cavey, a bona fide tenant by partnership, Mr. Payne signed the lease on behalf of their partnership, and he has testified that he has had, at least 40 head of cattle, and he has used that parcel continuously since 2018.
Mr. Chair, Crosby has a question when you're ready.
Let me hang on a second. Let me get the county attorney to weigh in on that.
I just want to bring us back to a point that the assessor had mentioned in the beginning of his argument, which is none of this
Is relevant, yeah.
is relevant.
Because the original claim wasn't filed within 60 days of purchasing the property to transfer the ag status, nor an ability to verify by the assessor because he never received that there was actually an
There's
ag
actually no error existing. Correct.
Right.
So that's
Right.
correct. And then also the way that this has been brought to us procedurally is through the hearing officer for the BOE that we contract with. And she's constrained in what she can do in this type of appeal, which was a notice of error. And so here's the statute 42.16256
Yeah.
that Phil had alluded to. And subsection D says this article does not authorize an independent review of the overall valuation or legal classification of property that is not the result of an error. So we're going a little bit out of our way, and it's
Right.
good to give the guy a hearing and due process, but this wasn't something that was properly before the hearing officer to begin with.
Right. So what I'm getting at is that regardless of whether or not it's currently being used or not, that comes back to the original upon purchase in 2021. There was not a filing of a transfer of ag use application within 60 days of that purchase to transfer the ag use.
That's correct.
That is the basis of this whole thing. And that he hasn't gotten one now, from what he's telling me, until 2024. And then I guess the clock would start all over for the 3-year period for him after that point.
Well, the 2024 application was denied already by.
Oh,
my
it was
office.
also denied.
Yes. So we move forward from there. So, but basically, yes, that's correct.
The 3-year clock would start because he missed the window for the transfer. He's got to restart the 3-year clock.
Yes, and we do take all of that in consideration when we have an application. We do the physical inspection. We determine, the user, the lessor, the lessee, the entire ramification of that process.
Now, I did submit that application, and the assessor's office did testify that they're aware of applications being lost. And that said, I clearly did call, and I have phone calls and emails over the next, 18 months where I was consistently told to just sit tight and be patient. So I believe that's also an error. The first time I called, someone should have said to file another application. It wasn't until, November 23, they said, you know what, we just can't find it. Send another one and file again. I believe that's also an error.
There's no records. My office does not have records to that early of contact. During 2024, there was a series of phone calls to my office by Dr. Latowski, continuous phone calls. And as he mentioned, to the point where my office had to ask him to quit calling because of the point that we could not address an issue that he was wanting us to address. Again, my office does not tell people not to file an appeal. We do not do that. If you're challenging a 2022, a 2023, or a 2024 valuation after the fact,
Right.
we're going to explain that that's not subject to an appeal.
Right.
The appeal deadline is passed, both administrative and judicially. Now, when someone is saying, for example, if I have a taxpayer call in and say, I sent you an application and you don't have it, my staff is not going to poke them in the eye. They're going to say, it's possible we've misplaced it. Let us look. But after we've done, we've searched the files. We don't lose files. My clerk might have been trying to be pleasant, say, well, we could have lost them. We don't lose files like that. We've got very few instances of ever losing a file such as this that's sent to us. It could happen, yes. But my point being that if, in fact, a 2022 application was sent to us and he heard nothing back from us, yet received a 23 notice of value, a 24 notice of value, a 25 notice of value, notifying him of a $300,000 value on his property, not ag classification. Nothing was said. That's kind of hard to explain. When, as he mentioned, after he got his tax bill in 2023, the lights dawned, apparently. But the appeal deadline and the notice to file a claim, the administrative appeal, judicial appeal is far past for those years in question.
Contrary to what Mr. Landecker had just stated about not having any records, before 2024, I do have emails from Annette Shannon with Joe Alvarez carbon copied that say, here's the land lease application. As we discussed on the phone, please do send the original signature and application, but I will be able to get the ball rolling with an electronic copy and send the second copy in now. Thank you. I hope you have a lovely day. And then it says, I will place the information in your file. I will get a hold of you or Mr. Payne if we have any questions, and we will notify you by mail when we have finished our process with the land use application. This is from November 2023, and this was kind of my point. And frankly,
that was
the grant,
reviewed and denied.
That was when we were sending to him.
Yeah, but you got that when you reviewed that, when you denied it because, again, this guy didn't have 40 head of cattle.
Yes. And a standard procedure, people call us time and we will send them applications. That's standard procedure.
All right. All right.
but again, Kenneth Cavey has testified that he has run cattle on there, and per the statutes in the Ag Manual, that's all that's required to justify grazing status.
Mr. Chair, I have a question for Mr. Correa.
Go for it, Mr. Crosby.
Mr. Correa, I've heard the term owner-operator in this discussion, and so I might have a question that is irrelevant, so I thought that I would let you hear it. And that question is, do adjacent parcels, Mr. Letowski notes, are taxed differently, have precisely the same owner-operator status? But if that is not relevant, then we'll just forget about it. I'd be glad to repeat it.
Supervisor
One of the
President, that's
parcels
more of
has
a
the
question
same
that Phil
tenant.
could answer because
But
that's a
but
fact
he
question.
explained that. He said that the neighboring properties had another gentleman that was the primary registrant of the cattle, not the individual in question here that signed the lease with Mr. Letowski.
And to address that issue, the issue continually coming up is the fact that there's cattle on the property automatically qualifies it as agricultural. That's an incorrect
That
statement.
is incorrect. I know
That
that.
is totally
well.
incorrect.
Yep.
And if other people apply and do their paperwork correctly, then they have that benefit. If not, they don't.
Okay, well, I don't know if we heard from Mr. Correa there or not, but it seems that the answer to the question is no, they do not have precisely the same owner-operator status on the adjacent parcels.
May I ask a question, Sharon?
Go ahead.
I guess I'm going back to the point, when is a person, so Dr. Letowski bought this land, it's agricultural, and I don't know what his purposes were, to run cattle or just to have land, but is there a commonality? I mean, do people find this out? Hey, you bought agricultural and you have to file this, this paperwork in 60 days. Is that part of the real estate exchangement, or is this just something they're supposed to know?
It's generally something, Dr. Letowski had mentioned that he's done this before.
Okay.
He has other property that is orchard land.
Okay.
And he stated that he's bought this for the purpose down the road of orchard.
Pistachios.
Yeah.
Okay.
Pistachios, right.
So
Okay.
to answer your question, people don't pay $850,000 for a piece of land and be ignorant about.
Yeah, there was
what
likely a
process.
real estate attorney involved with this transaction, or
I would
someone
think so, right?
someone licensed to do the transaction, which should have brought the issue up.
Okay.
That's
was
an
not.
assumption. That's an assumption. Is
There
that the
was
case,
not.
sir? Did you have an attorney with you?
No,
For
in
this-
fact, the way that this happened is not exactly as described. The property which we drive by, it's between my parcel and Cochise Stronghold. It's a beautiful piece of property. And we had met Mr. Payne at one time, and we saw a for sale sign, and then we saw a sold sign. And we just stopped in to say hi to Mr. Payne, and he said he had just sold it to a property developer from California. And we were crushed with the idea that they were going to be putting in, a housing development there. And we said if there was any way that he could get out of that, we'd buy it and lease it back to him for cattle, for him to run his cattle that he runs in a joint herd with Mr. Cavey. who is a qualified tenant and has testified in writing that he is my tenant.
So you just bought it? You just wrote the guy a check and he just did a quick claim deed and transferred the property?
Yeah, from a fifth wheel trailer on my orchard there while I was trimming my trees.
It's I think the caveat emptor applies.
Mr. Chairman,
Fortunately.
also to address Supervisor Gomez's question, by statute, my office has to notify a property owner every year of the valuation.
Right.
To your question, to your point, if you buy a piece of property and you get a valuation notice the next year that says it's not ag, you have the ability to appeal that.
Okay.
And under the appeal process, at that point in time, you can file paperwork under appeal.
Okay.
So there is a protection in place to protect people from that.
Okay.
In this
If I could-
situation, that didn't happen.
If I
All
could
right, this
point
is
out
it,
one
Mr.
thing.
Todd. I'll let you make a closing statement and then we're going to wrap this
Well, I
up.
just had a quick point, I mean, that would help people, but when you get the, the full cash value, it doesn't mean anything. It doesn't, to me, it might to an assessor, but not to a landowner. You don't understand how the assessed value converts to the taxation, and that information is not on that little piece of paper that you get. And further, they don't say anything about grazing status. It's a code. So like my code changed from something like 4170 to 0004 or vice versa. I mean, that doesn't mean anything to me. So I would have no idea that my tax bill went from $36 to $7,500. It's concealed from
you don't
the,
receive a tax bill from the treasurer?
well, you get a notice of valuation that just says FCV and another number, but it doesn't convert to taxes. And then, but again, yeah, the tax bill comes like twice a year I believe in the summer and then in the fall. And it wasn't until I got the tax bill that I realized that, the codes on the card mean that my tax bill had increased by 188 times.
But that should have been the first year, right?
It was.
All right.
That's when I started calling.
Okay.
And I kept being told to wait.
All right. That's appreciate your time, sir. Thank you, Mr. Leindecker. Appreciate your time. The motion is to recommend to ratify, or amend. So I would need a new motion.
Let's see where.
Basically to amend the decision of the State Board of Equalization hearing officer and go with the county assessor's recommendation regarding the notice of claim appeal hearing held on January 8th, 2025 for tax years 22, 23, 24, filed by the petitioner, Stronghold Farms, LLC. Mr. Crosby, are you able to make that motion? Or can you make it, Ms. Gomez?
Is it this page right here? Yeah, it's maybe page.
Just read.
Yeah, okay, that one.
Motion to amend.
Okay, there's a motion to amend the
No,
decision.
you make the motion.
Oh, I make the motion to amend the decision of the State Board of Equalization, SBOE, hearing officer regarding the notice of claim appeal hearing held on January 8th, 2025 for tax years 2022, 2023, and 2024, filed by petitioner Stronghold Farms, LLC, Aaron Latowski.
Do I have a second? I'll second it. I don't know if Mr. Crosby's offline or not.
That's negative. I'm online and I'll second it, but
Okay.
you already have, so all is well.
All right. All right. So all those in favor say aye.
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 All right. Motion carries 3-0. That's it. The next meeting will be a work session today, February 20th at 1 p.m. in this hearing room to discuss possible direction regarding the Public Works information update. We are adjourned.